Thank you, Senator. Good morning. My name is Tamar Kraft-Stolar. I'm the director of the Women in Prison Project at the Correctional Association, as you mentioned. We're a nonprofit criminal justice policy advocacy organization with a unique statutory mandate to monitor prison conditions. And I really want to thank you, Senator Hassel-Thompson, as well as Senators Kruger and Senator Sampson, and the entire Senate Democratic Conference for organizing this important forum and for the opportunity to testify about the Domestic Violence Survivors Justice Act. Domestic violence, as you know, affects women in prison in staggering numbers. 9 out of 10 women in prison have suffered from some physical or sexual abuse in their lives. 8 in 10 have suffered physical or sexual abuse as children, and 75% have suffered severe physical or sexual assault by an intimate partner during their adulthood. Incarcerated women are a critical part of any conversation about domestic violence, and we're grateful to you, Senator, for your recognition of this fact, and to Assemblymember Jeffrey-Ann Aubrey, as well as yourself, for sponsoring the Domestic Violence Survivors Justice Act. All too often, when a survivor acts to protect herself against her abuser, the criminal justice system's response is to incarcerate her, often for long periods of time. When this happens, it represents a shameful miscarriage of justice. Instead of giving survivors who have suffered years of life-shattering abuse compassion and assistance, we give them harsh punishment and prison. Instead of providing protection, the criminal justice system becomes just one more entity in the continuum of violence in survivors' lives. Our state's mandatory sentencing statutes are responsible for much of this problem. The statutes require judges to dispense long prison sentences to survivors, even when they determine that an alternative to incarceration program, an ATI, is a more appropriate sentence. Because judges lack discretion, ATI programs are only possible if a prosecutor agrees to drop the charge to a lower offense. This is a rare occurrence. The Domestic Violence Survivors Justice Act would take significant steps to address this problem. It does 2 things. It allows judges to send certain survivors convicted of crimes directly related to their abuse to either significantly shorter prison terms or to ATI programs. And it would also allow certain DV survivors currently serving long prison sentences to petition the courts for resentencing and earlier release. To be eligible for alternative sentencing or resentencing, a judge must find that a survivor meets 3 specific criteria. 1, that at the time of her offense, she was a victim of domestic violence, subjected to substantial physical, sexual, or psychological abuse inflicted by a spouse, intimate partner, or relative. 2, that the abuse was a significant contributing factor to the crime. And 3, that a sentence under the law's general sentencing provisions would be unduly harsh. It is important to note that individuals convicted of murder in the first degree, aggravated murder, sex offenses, and terrorism offenses are excluded from eligibility under this bill. Because at its core, the Domestic Violence Survivors Justice Act is about returning discretion to judges, we don't know exactly how many people it would affect. What we do know, though, is that it will not affect very large numbers. We estimate that roughly 240 women survivors per year would be eligible for alternative sentencing under the bill, and that about 175 women who are currently incarcerated would be eligible for resentencing. Overall, the Domestic Violence Survivors Justice Act is not a radical bill. It does not allow a survivor defendant to contest her conviction, and it does not allow incarcerated survivors to secure an automatic release from prison. It merely grants the court appropriate discretion in certain cases to consider the DV experienced by the defendant as a mitigating factor in determining sentence type and length. This act is supported by a broad coalition of over 100 domestic violence, social service, criminal justice, and women's organizations, and by thousands of individuals across the state. In a PBS poll conducted earlier this month, 92% of respondents said they supported reduced sentences for DV survivors convicted of crimes related to their abuse. The only opposition that the bill has received thus far is from the New York State District Attorneys Association. Unfortunately, the DA's opposition to this legislation is misguided and based on misinterpretations of the bill and misstatements about its impact. I'm going to briefly summarize 5 key points from their memorandum. The DA's association that the bill is, quote, claims that the bill is, quote, overly broad and would permit individuals with, quote, no direct causal link between their crime and the abuse they experienced to receive more lenient sentences. For someone with no direct causal link between their crime and their abuse to receive an alternative sentence under this bill is a statutory impossibility. The bill explicitly states that the defendant has to be a victim of domestic violence at the time the crime was committed, and that violence has to be a significant contributing factor to their offense. A history of childhood abuse does not make a person eligible under this bill. In addition, to make use of the alternative sentencing, the Act requires a judge to hold a hearing where both the prosecution and the defense can present oral and written arguments. Only after hearing from both sides and considering evidence can a judge exercise her discretion under the bill. Finally, judges are not obligated to use their new discretion. Nothing in the Act precludes a judge from giving a longer sentence if they deem it necessary. Second, the DA's Association objects to the Act's inclusion of survivors convicted of crimes not against their abusers, but directly related to the abuse they've suffered. This opposition reflects a lack of recognition of the complex role that domestic violence plays in a survivor's behavior and actions. Abusers often force survivors through a range of power and control tactics to participate in crimes like robbery, burglary, forgery, drug sale, shoplifting, and prostitution. Not including survivors in these situations would force us to turn a blind eye to the suffering endured by many victims. It would also create an unjust double standard where a woman who was convicted of shooting her abuser would be eligible for alternative sentencing under the bill, whereas a woman who obtained a gun for protection against her abuser would not be eligible. In effect, it would penalize survivors for not committing physical acts against their abusers. Third, the DA's Association claims that the existing domestic violence exception created as part of the 1998 Sentencing Reform Act, known as Jenna's Law, is sufficient to address the special circumstances facing survivor defendants. Although the underlying concept of this law is very positive, the law has been a complete failure. Here's a brief summary of the reasons why. First, the exception only applies to survivors convicted of crimes against their abusers and does not consider crimes where the abuse was a significant factor in the defendant's actions. Second, the exclusion accepts convictions of murder in the second degree. Third, the exception only allows mandatory prison penalties, not ATIs. Fourth, the exception does not sufficiently reduce sentences. For example, a survivor who assaults her abuser could still serve up to 25 years in prison under this exception. Fifth, the exception may actually lead to longer prison terms than those available under the general sentencing statute, though one person serving time under this exception in 2007 was given a sentence that was longer than the minimum term allowed under the current guidelines, and he was denied parole twice. And finally, the exception has been rarely used. The New York State Sentencing Commission, appointed in 2007, according to them, only one person was serving time under this exception in 2007, and in 2009, not a single person was. Fourth, the DA's Association contends that the bill does not, quote, give adequate consideration to its impact on public safety. This act poses absolutely no risk to public safety. The vast majority of survivors convicted of crimes related to abuse have no prior felony convictions, no history of violent behavior, and extremely low recidivism rates. Just a brief statistic, 80% of women sent to New York's prison for a violent felony in 2009 had never before been convicted of a felony. Of the 38 women convicted of murder and released between 1985 and 2003, not a single one returned to prison within 3 years of their release. That's a 0% recidivism rate. In addition, ATI programs are more effective than prison in reducing recidivism and allowing survivors to heal from abuse, reconnect with families, and rebuild their lives. ATIs are also up to 5 times less costly than prison. And finally, last point, the DA's Association argues against having a retroactivity provision in the bill. That's the resentencing provision. Including a resentencing provision is central to this act's intent and to its purpose and to the fair application of any sentencing reform effort. When a reform bill of this type becomes law, it signifies the legislature and the governor's recognition that the prior sentencing statute was too harsh. That recognition should extend to those convicted before the law's passage as well as to those after. Denying resentencing eligibility to survivors who, but for their conviction date, would have been eligible for an alternative sentence is arbitrary and unjust. In conclusion, for too long, our criminal justice system has overlooked the particular circumstances of DV survivors who act to protect themselves. We need to do more and to do better. We urge the legislature to pass the DV Survivors Justice Act, and in so doing, to help our state take critical and long overdue steps towards treating survivors who act to protect themselves with the justice and the dignity and the compassion that they deserve. Thank you so much for giving us the opportunity to testify here today.
Thank you.